time. I don't think there's too much overstatement that can be said about this election, this presidential election, and all the ramifications and its impact on LGBT rights and equality. And before I start, I just want to make it very clear is that the ACLU of Michigan, we are a nonpartisan organization. We don't endorse specific candidates or parties. So I'm not going to be telling anybody who to vote for. But I think it's very important that we be informed about the issues and how, if we care about LGBT rights, how the election can determine where we're going in this area. And I don't know if many of you, I'm on Facebook, and I saw something was circulating through the social media the last couple of days. There was a story about a grandson and his grandmother, 94-year-old grandmother, who staunch Republican, voted for Trump in 2016. And he decided to have a conversation with her about the impact of the Trump administration, their policies on LGBT rights, just as a way to hopefully maybe educate his grandmother and what his concerns were about that. And the story is basically, she listened to him and she heard about what were the facts and were the information. And she then made a determination on how she's going to vote. And it did have an effect on how she was planning to vote. And I imagine within the PFLAG family, there might be opportunities for conversations with loved ones. So they have an understanding really what's at stake. And anybody who tells you that there's no difference between the two candidates at the top of the ticket and what their impact would be on LGBT rights simply are not following the news and are not informed with what's going on. So before I get into some of that, I wanted to talk about what is the state of LGBT rights at this point in time. On June 14th, just a couple months ago, we had a historic decision from the United States Supreme Court. That case is called Bostick versus Clayton County, and it involved 3 cases involving LGBT employment discrimination. 2 cases involving gay men who were fired from their jobs when it was discovered or presumed that they were gay. And then the 3rd case involving a transgender woman, Amy Stevens, who was fired from her job when she disclosed that she was transgender. I should mention that the ACLU of Michigan, we were involved with Amy Stevens' case from the very beginning when she was fired, and that the ACLU represented 2 of the plaintiffs in these discrimination cases before the United States Supreme Court. What the court did was they held that LGBT employment discrimination is considered to be sex discrimination. And when you choose to treat LGBT employees unfairly, you are violating a federal law called Title VII, which prohibits employment discrimination on the basis of sex. Why is that so important? Well, first of all, the court made it very clear, the court majority made it very clear that when you are singling out LGBT people for discrimination, it's on the basis of sex, the sex that was assigned to them at birth, their inability to conform with society's stereotypes regarding a person's gender, and that kind of discrimination is inextricably bound up in sex. Why is this decision so important? Because out of the 50 states, only 29 states actually, I'm sorry, I was wrong. Out of 50 states, only 21 states have civil rights laws that explicitly cover sexual orientation and gender identity. Michigan is not one of those 29 states. Of 21 states, we're one of the 29 states that don't have that explicit mention in our civil rights laws. So by seeing this as a form of sex discrimination, which is a covered category, it now provides remedies for LGBT people who've been discriminated against in their employment. And that's a very important tool that we'll be able to use, and that we want to be able to use that tool, use this case, use that analogy and that decision to challenge discrimination against LGBT people in other contexts, like housing, like education, like public accommodation. So it's a very, very important decision, a landmark decision. It was a 6-3 decision, which made it very clear that the Supreme Court majority saw this as a form of sex discrimination. And I'll be honest with you, there was a lot of fear and trepidation in the LGBT community when the court decided to take up this case, because we didn't think that necessarily there would be the votes there. What really happened is the way the argument was framed to the court, it was kind of framed as a simple reading of what does sex mean? You know, what does because of sex mean? And that fortunately appealed to Justice Gorsuch, who's one of the more conservative justices, who kind of only looks at what the actual language says. So we're very, very pleased with this decision. For us at the ACLU of Michigan, of course, it was a very bittersweet decision. Our client, Amy Stevens, passed away about a month before the decision came down. She had been in ill health for the past couple of months. And this case meant so much to her, and her involvement in this case, you know, when it has devastating consequences, not only financially, but on one's self-esteem, one's sense of purpose. And I like to believe that Amy found a second sense of purpose in the last year of her life, being the face of this Supreme Court case and telling her story as a way to make things better for other people who are transgender. Now, as I mentioned to you, Michigan does not have that explicit mention of sexual orientation and gender identity. For more than 30 years, legislation has been introduced that would amend our state civil rights laws to include sexual orientation and gender identity. And what seems to happen just about every time is the majority House leader and the majority Senate leader will not let these bills go forward to get committee hearings and to be voted on. And that's the case right now. The Republican majority, the leadership in both the House and the Senate, have refused to move these bills forward. So it still remains in limbo. There's also been some federal legislation that would create the first federal civil rights law for LGBT people. It's called the Equality Act. It passed in 2019 out of the House of Representatives, a clear majority voting in favor, but current Senate Majority Leader Mitch McConnell will not allow this bill to move forward in the Senate. And President Trump has indicated that if such a bill were to pass out of both the House and the Senate, that he would veto it. So that's where we're at. I should also mention in Michigan, we're fortunate in that our Civil Rights Commission 2 years ago interpreted our state civil rights law as covering LGBT people. Now, that's not a court decision, it's an interpretation of the law. But since that time, the Michigan Department of Civil Rights will take LGBT discrimination complaints in employment, in housing, in education, and public accommodations, and they will investigate them. So we have this important tool, but this issue still hasn't been litigated by our courts. And I'm going to be talking about the importance of the courts in terms for LGBT rights. And why that's so significant, and how it ties in with this year's election. So some of you have heard that there's going to be the start of confirmation hearings on behalf of filling the vacancy left by the untimely death of Justice Ginsburg. But you might not have heard what's also going to be happening is on November 4th, the day after Election Day, the Supreme Court is going to hear the next LGBT rights case. And it's in a case called Fulton versus Philadelphia. And that involves the city government of Philadelphia that gives out contracts to foster care agencies to provide foster care services, to place kids in home and to work with foster parents. And that includes faith-based agencies. And there is a faith-based agency that had a contract with the city of Philadelphia that said, you know what, we're not going to comply with your language, your non-discrimination language in the contract that says you can't discriminate based on sexual orientation. We are not going to work with LGBT families. We won't work with them to become foster parents because of our religious beliefs. And so the city of Philadelphia said, well, listen, if you're not going to comply with this language, then we're not going to continue granting you money to perform the foster care services. And so this faith-based agency then sued the city of Philadelphia, saying that that violated their religious freedom, that they have a constitutional right to a government contract, and that because of their religious belief, they should be able to be carved out, get a carve out from complying with this non-discrimination language. This is a real seminal case in terms of LGBT rights, because what we're seeing on behalf of many opponents of LGBT rights is this attempt to try to use religious beliefs as a way to not have to comply with non-discrimination language. And not only using it as a defense, but also proactively using it to challenge non-discrimination policies. And of course, once again, we have a great deal of concern with what the Supreme Court might do with this case. You know, the majority decision in the Bostock case, Justice Gorsuch made it clear that they weren't looking at, you know, in terms, well, let's say the employers were raising religious defenses as to why they fired the LGBT employees. So this is kind of a new thing that the court's going to be looking at. And as of today, there is a 5-4 clear conservative majority on the United States Supreme Court. If Amy Coney Barrett is quickly confirmed to take, you know, Justice Ginsburg's place, then you have a 6-3 conservative majority. And in the worst scenario, you would find the court saying, yes, there is a carve out to civil rights laws based on religious beliefs when it comes to LGBT people, which is a very, very dangerous thing. And let me tell you, I've been with the ACLU for almost 20 years, and I can make it very clear that you know, as far as our knowledge with the Constitution very strongly protects an individual person's religious beliefs or organizations' religious beliefs. There's nothing that the government can do to take away someone having a particular belief because of their faith. However, our Constitution, our courts have never allowed a religious belief to be used as a sword to harm other people in non-religious settings. Just, you know, as a historic example, in the 1960s, after the Civil Rights Act of 1964 was passed, you had restaurant owners in the South saying, you know, my religion tells me that God placed the races on separate continents, and therefore I shouldn't have to serve Black people at my restaurant. The courts didn't accept that argument then, and they shouldn't accept that argument now. But this is what we are seeing ourselves up against in terms of, you know, a potential litigation. And mind you, if you take out the word gay or lesbian or transgender and you put in another group that might not meet the approval of an individual, them citing their religious beliefs, you could see the words race, you could see the words other religions that could be fitted in there. Just as an example, the Trump administration earlier this year allowed states, in terms of their foster care programs, to be able to grant exemptions from complying with non-discrimination language based on religious beliefs. So you saw in South Carolina granting an exemption to a faith-based foster care agency that has a government contract to provide services that said they didn't want to work with a Jewish family, and they were permitted to do so. So we start to go down this very slippery slope. I should also mention that we have 3 similar cases to what the Supreme Court is hearing on November 4th in Michigan, involving faith-based foster care agencies that are suing the state of Michigan because they don't believe that they should have to comply with the non-discrimination language, and they refuse to work with LGBT families. Let me just kind of go back to what's probably the most important thing when we talk about foster care services. We want to provide children who are wards of the state with loving, stable homes. When you exclude from and what we know in the state of Michigan is we have way too many kids who are wards of the states who need foster care placements, who need permanent adoption placements. And when you allow a practice that says, okay, we're going to automatically eliminate from the foster care pool, and thus the potential adoptive pool, LGBT families, we're actually decreasing the potential homes that could be available to these children. And at the same time, we're not taking into account that maybe some of those kids in the foster care system might also identify as LGBT and could use a supportive home, a place that they could go to. So this is highly problematic, and it's really not focusing on the best interest of children, but it's focusing on, it's putting first and foremost the religious beliefs of a particular organization. Now, when I'm talking about this, I'm not talking about the government telling a church or a synagogue or a mosque, how they're supposed to conduct their religious services, or anything in terms of their, the ministerial functions of their faith. We're talking about non-religious activity. And yet we're also seeing attempts, and I think some of you you're aware of, a cake baker who doesn't want to bake a cake for a same-sex couple who's getting married, or the florist who doesn't want to do floral arrangements for that same-sex couple, or the person who rents their land for wedding celebrations who doesn't want to do so for same-sex couples, all citing religious beliefs. And I believe that this is the biggest threat to the gains that have made towards LGBT rights. If we start allowing this sort of carve out for civil rights laws, it's a slippery slope. That's good. And, and I think there seems to be this understanding, or this tacit understanding, that when we're talking about religious beliefs, we're talking about Judeo-Christian beliefs. We're not talking about necessarily Muslim beliefs or any other faith. And it'll be interesting to see, how courts and how proponents of this idea that I should be religiously exempt from complying with certain laws because of my religious beliefs, how they're going to respond to when it's a faith that might be considered to be outside of the mainstream. But it's a very dangerous thing. And when you look at in terms of foster care services, and you're talking about government contracts, let's say if the state of Michigan says to a faith-based agency, yes, you can refuse, you can be our agent, we'll give you money, and you can refuse to work with that same-sex couple because your particular religious belief that same-sex couples should not marry, or whatever that is, then what you have is a violation of separation of church and state. A government agency putting forth a particular religious belief in terms of providing government services and using taxpayer-funded money to provide that service. So we want to look very, very closely what's going to happen in this court. And clearly we know that that a candidate such as Amy Coney Barrett, based on other holdings that she has been a part to, as well as her strong opposition to the marriage equality decision that the United States Supreme Court delivered 5 years ago, I think it's fairly easy to speculate if she does hear such a case like this, how her vote might go. And so that's why it's very important that we be informed and that we understand that not only is it different policies, but it's also what is the fate of our court system as a result of these elections. In his almost 4 years in office, President Trump has been able to appoint more federal judges to the federal bench than any president in the history. In that period of time. These are lifetime appointments. We know that underneath the United States Supreme Court, the second highest level in the federal courts is the Circuit Court of Appeals. We know that of the ones that he has appointed, 1 out of 3 of those judges who've been appointed, and by the way, there hasn't been much diversity. I think there's been no people of color who've been appointed on this court and have been, approved by the Senate. But we know that 1 out of 3 of those judges in previous decisions have decided against LGBT rights, either on basis of religious beliefs, religious belief defense, or opposed to the right to marry and recognizing LGBT families. So that has a significant effect. When you appoint somebody to a lifetime appointment, let's say they're age 45, they could be on the bench for 40 years. And there's an opportunity to really reshape and to change in terms of how our federal courts look. I can just give you an example. Michigan is part of the Sixth Circuit Court of Appeals, which covers Kentucky and Tennessee, Ohio, as well as our state. And prior to 2016, the ideological makeup of that Sixth Circuit Court of Appeals was kind of 50-50, and you knew you kind of had a chance. You'd get a panel of 3 judges and you hope that things would turn out right. As a result of the appointments and vacancies that the Trump administration has been able to fill, that trajectory has changed. And it's clearly there's more of a conservative balance on that court. And what that means is the ability to successfully bring civil rights claims it becomes more precarious. It becomes more difficult to be able to do so. And I just want to give an example back to this use of religion. Again, some of you might be familiar of the community of Williamston, which is right outside of Lansing. It's a little bit east of Lansing. And about 3 years ago, their school board passed a non-discrimination policy that included sexual orientation and gender identity for students. And a group of parents who were upset about that, they sued the school district, saying that the school district, by having an LGBT supportive policy, that violated the religious freedom of these parents to be able to instill the values that they wanted to instill to their children with regarding being LGBT. The case right now is kind of just been in limbo. The judge hasn't done anything about it, but this is an example, another example of proactively challenging attempts or efforts to provide for LGBT equality, citing, by having a policy that treats LGBT kids equally in school, that's violating my religious freedom. I don't think that challenge has a leg to stand on, but we just don't know. We just don't know from some of these new judges who are being appointed. And then I want to bring it back to in terms of our state courts. I've been with the ACLU, I mentioned before, it's going to be 20 years next year. And in those 20 years, basically, we've kind of viewed our state courts have been being pretty much closed off in terms to be able to successfully bring civil rights claims. In other words, for almost 2 decades, the Michigan Supreme Court has had a conservative majority, and therefore it's very difficult out of 7 justices to successfully bring a civil rights claim. And certainly we've had a number of anti-LGBT decisions from that court. One thing that people don't understand is when you vote, you get your ballot, it says nonpartisan for the Michigan Supreme Court and the Michigan Court of Appeals. That's really not true. Those candidates for those positions are nominated by the political parties. And sometimes those candidates, their judicial philosophy reflects their political party. But most people don't know that. Well, for the first time in many a year, there's a vacancy on the Michigan Supreme Court. One of the justices, Justice Markman, is retiring. Michigan has a law that says once you're 70 years old, you can't run again for the Michigan Supreme Court. So there's an opportunity to change the current conservative 4-3 trajectory on the Michigan Supreme Court, pending the outcome of this election. And I'm looking at that. That's so very important that happened, because as we've seen the changing makeup of the federal courts, we're going to need to very much rely on our state courts to be able to do the right thing. And so I highly encourage, if you haven't voted yet, that you really pay attention to what people are saying about the Michigan Supreme Court election, who are the candidates, to try to find out what their viewpoints, and to really make an informed decision. This is not one to skip. It's very, very important. Doesn't look like the Michigan Court of Appeals, any of these candidates are being opposed, but also they are predominantly, it's a conservative majority on the Michigan Court of Appeals. So our real hope in terms to move LGBT rights forward, aside from from what happens with the legislature, is to be able to do so through the courts. So I wanted to mention that. A couple of weeks ago, I was once again on Facebook, and there was somebody from the LGBT community bemoaning the fact that there was no difference between the 2 candidates for president. And there was, what's the point of even voting yes, thank you, Michelle. Pridesource.com is very, very helpful. You can put in your zip code. They'll tell you who's on the ballot. They'll also tell you which candidates filled out the survey with regards to LGBT rights. And, and also they also endorse different candidates. And also the League of Women Voters is also a real important, good resource that people can check on there as well. But so anyway, this person was saying there's no difference between the 2 candidates. Well, I just want to go through a few things that, if this was 2016, it was October 11th, I could tell you that the landscape looked a lot different than it looks now in terms for LGBT rights. Remember, in 2016, just the year before, we had this historic decision regarding marriage equality. And I think there was a perception on the part of certainly the media and other people that, well, LGBT rights, it's all accomplished. There's nothing more to do. But of course, there's a lot more to do. And as a result of policy changes, we've had to take some steps back and have to, engage in new kinds of fights. And I just want to give you a few examples with this current administration. When they came into office, there were guidelines concerning transgender students and the ability of trans students to be able to use restrooms in schools in accordance with their gender identity. It was specific guidance from the U.S. Department of Education. Though that guidance was rescinded by the Trump administration. And the only ways that trans students have been able to challenge when they've been denied the ability to use restrooms in accordance with their gender identity is through a lawsuit. But the U.S. Department of Education is no longer taking complaints of trans discrimination against trans students with regards to being able to participate in things in accordance with their gender identity. Also, what we've seen recently is the Department of Education is opposing the ability of trans athletes to be able to participate in school sports in accordance with their gender identity. There's some litigation going on, and the Trump administration, the Department of Justice, is in opposition to that. Also, Betsy DeVos, head of the Department of Education, has threatened to take away funding from public schools that permit trans students to be able to participate in sports activities in accordance with their gender identity. Should also mention that the Department of Justice, in those cases that went before the United States Supreme Court, they opposed the LGBT community. They argued that sex discrimination laws did not cover LGBT people. They went before the Supreme Court and they argued on behalf of these employers who had done the discrimination. I should also mention that the agency that we filed the complaint on behalf of Amy Stevens is called the Equal Employment Opportunity Commission. It's a federal agency that investigates employment discrimination complaints. And at first, they were gung-ho on behalf of Amy. They actually investigated her complaint of discrimination. They actually brought charges against the funeral home operator. But when we went but that was before the 2016 election. And when we went before the United States Supreme Court last year, they argued against Amy. And they said that she had no right to protection against discrimination as a result of changes to the head of the EEOC and also because of the Department of Justice. Some of you are aware that President Trump reinstated the transgender military ban through a tweet, which reversed the Obama administration. That policy is currently in litigation. But what also happened is the United States Supreme Court has permitted this ban to take effect while it's winding, the cases are winding its ways up through the federal court. So transgender new military recruits are not permitted to sign up for the armed forces, and a transgender person who comes out after they've already actively been in the military, they don't necessarily have a right to be able to present themselves in accordance with their gender identity or to receive any medical care in accordance with that gender identity. The Trump administration also came out with a policy called the medical conscience rule, which permits any person who's considered to be a medical personnel, might even include the office worker in a doctor's office, they can refuse to provide services citing deeply held religious beliefs or religious or moral beliefs, which is a very, very wide term. And there has been some litigation over that issue. And in one of the depositions they took, the administration even admitted that, let's say a situation where you had ambulance workers who were running out to someone's house and decided, found out that somebody might be LGBT. If that person was able to cite some kind of religious belief, they can refuse to provide that sort of treatment. Now, we've got a good federal court decision in one of the federal courts striking down this policy as unconstitutional, but that's not the end of it. There's going to be more litigation on these issues, and it's going to go to more courts, and we'll have to see how that comes out. The Obama administration had a policy concerning health insurance, and healthcare services under the Affordable Care Act, or the Obamacare, which said that it's very clear that the non-discrimination provisions cover LGBT people on the basis of sex. The Trump administration reversed that interpretation, and they're arguing that LGBT people are not protected under the Affordable Care Act from discrimination, and that the federal government will not take discrimination complaints if, let's say, a transgender patient is denied medical care. This is also being litigated. The Trump administration also came out with new HUD regulations concerning homeless shelters. And they said that homeless shelters, particularly if they're faith-based, they can turn away a transgender individual. They can require that that it's based on the sex that was assigned at birth. So if a transgender woman comes to a homeless shelter for women, she can be turned away, and they can say you have to go to a men's shelter. And they also, it's so interesting in that they provide guidance on how they leave it up to the individual shelter provider to decide whether or not someone's transgender. So they talk about, if you see somebody who says they're female but has a deep voice, or has an Adam's apple, or might have hair on their face, that can be a basis to turn them away. Now, this is government-funded homeless shelter providers who are permitted this kind of discrimination. I know I'm leaving a lot of things out, but I think you're getting the picture that, we've seen a lot of reversals in terms of progress that were made in the previous administration. And these are some of the policies of the current administration, which, seems to be promoting discrimination against LGBT people and saying, and denying even, so just as an example, the HUD regulations came out after the Supreme Court decision that said discrimination against LGBT people is sex discrimination. And even despite that, saying that you can't do that, the HUD regulations still said you can go ahead and you can single out transgender people for discrimination, that they're not protected, that you only define sex based on what sex was assigned at birth, as opposed to a person's gender identity. So I know I'm throwing a lot of things out at you, but as you can see, there's a lot that's at stake in terms with where we go and how we move forward in terms of LGBT rights. And I know I've talked to some of my friends, and I know it's in these very polarizing times. I know many times we might have family members or friends who might have a different political viewpoint and might support somebody different than we do ourselves. And the difficulty in being able to have conversations or to see if there can be some common ground, in having a political discussion. But I just want to urge people, if there's a way, for people to understand the impact on this election on LGBT rights. And if you're able to have that conversation like this young man was able to have with his 94-year-old grandmother, I want to encourage people to be able to do so, because this really can make a difference. I just want to give you an example too. We in 2018 in Michigan, we got a new governor, a new attorney general, and a new secretary of state. And as a result of that election, we got an executive order saying that LGBT people cannot be discriminated against by the state in terms of providing state services. We got the Secretary of State's office issuing a new gender marker change policy that didn't require a passport or a gender marker change on a birth certificate, things that are very difficult to be able to accomplish, but said you can fill out an affidavit over oath as to what your gender is, and we'll change the gender marker. Significant breakthrough. We have an attorney general who will, submit legal briefs in support of LGBT rights. And I can tell you, as an attorney for the first time in a long time, if there's a problem, let's say with the prison system, if there's a problem, let's say with the state's Medicaid program, I have somebody I can call in this administration to talk to about policies, and they will listen and they will consider about making changes. Whereas with the previous administration, I could send a letter, I could leave phone messages, I could send emails, I could send many, many letters and no response whatsoever. So elections can have consequences, they can have positive consequences, and they can make a significant difference. So I hope everybody will keep that in mind when you are making your choice, who you choose to vote for. So I'm going to stop talking to see if anybody has any questions. I hope I haven't left people just speechless.
So I'm not seeing any questions in the chat, Jay. I know you can see that as well. So I'll go ahead and unmute everybody. So if you have a question, you're welcome to ask Jay.
And I also wanted just to let people know, I muted myself, sorry about that. I just wanted to let people know, as a result of the 2018 election, we have so many ways that people can participate in our elections, in terms of the ability to, if you have an absentee ballot, a no excuse absentee ballot, the ability to go to your city clerk's office to request an absentee ballot and to vote in person from now all the way up until the day before the election. There are so many opportunities for people to participate. And there's a great website, it's called michiganvoting.org, that tells you about all your different voting rights and answers questions, and also talks about how you can help out with the upcoming elections. They need more people working at the polling places because just more people participating in our voting system. They need people to help count absentee ballots. And so there's ways that all of us can play a part. And I think there was, Mike had a comment or a question. How can we support the ACLU? Well, thank you. Thank you, Mike. Well, you can go to aclumichigan.org, and our website tells you about all the different issues that we are working on. I think it's important to note, so the ACLU, one of our things that we do is we represent people in courts in impact litigation, cases they're going to have an impact on a larger population. We don't charge for our services or our representation. Our services to the people that we represent are free. Actually, there's no charge for any services that we provide to people. So we rely on donations from our supporters to be able to do the work that we do. I'm happy to say that in the last couple of years, there's been an increased interest in the work that the ACLU is working on. We do a lot of work in the area of voting rights. We're doing a lot of work in the area of criminal justice reform, to reduce incarceration, bail reform. We're doing litigation in terms of COVID-19, in terms with trying to get individuals who are incarcerated who have health conditions to be able to be released under certain circumstances from prisons and jails and from immigration detention centers. We have several lawsuits challenging the government's policies regarding immigration, as well as some provisions regarding criminal justice reform. So we do a variety of things. And I should mention, the ACLU has been involved with LGBT issues for 7 decades. And there's a national LGBT project, but there's only about 5 state affiliates that have their own standalone LGBT project that focuses specifically on LGBT issues in their state. Michigan is one of those. And that's because of the commitment of our executive director. She saw kind of what was happening in Michigan, becoming more politically conservative, and she thought it was important to set up a project that was focusing specifically on Michigan. And I think there was a question. Are the prospects better for Fulton if any? Well, this is just me. Yeah, I do think the prospects are better if Amy Coney Barrett was not on the court, because I think if she does get on the court, you'll have a confirmed 6 conservative vote out of the 9 justices. And I think you'd have obviously a clear majority that would entertain this kind of religious exemption. I don't know if some of you saw just this past week, the Supreme Court, they refused to take a case. That was, some of you might remember Kim Williams. She was the clerk in Kentucky who didn't want to issue marriage licenses to same-sex couples. And she filed an appeal to the Supreme Court. They refused to take up her case, But Justices Clarence Thomas and Justice Sam Alito, they, on their own, they opined that the marriage equality decision was probably wrongfully decided, and that maybe the United States Supreme Court should take another look at this decision. You know, a lot of people, when after the 2016 election came to me, and they were very concerned, you know, what's going to happen with my marriage? I got married. Could they undo my marriage? I don't think a court decision could undo somebody's marriage, but what we're seeing is an attempt to try to weaken the Obergefell decision. In other words, to argue, okay, well, you have a right to marry, but you don't necessarily have a right to the benefits of marriage or to the recognition by the government in terms of marriage. And there has been some litigation in Texas that's pushing that sort of thing. Should also be mentioned that Amy Coney Barrett, after the Obergefell decision came down, she signed a letter with a number of other lawyers strongly opposing the marriage equality decision. So there's a question, why were there 50 circuit court vacancies that Trump filled? Why so many? Why so many? Because the Republican majority, the Senate majority, which was head of the Judiciary Committee during the Obama administration, would not move forward with Obama's nominations. You might recall that Justice Scalia died, I think it was almost 11 months before the November 2016 election. He nominated Judge Merrick Garland to the court. McConnell refused to move the nomination forward, citing an election year. That seemed to have changed this year. So a lot of the vacancies that were available in the previous administration couldn't go forward because the head of the Judiciary Committee, because the Senate leadership wouldn't let them go forward. However, this has been their first and foremost goal in the Trump administration, is to get as many judges nominated and quickly confirmed as possible. And that's why the rush on the Supreme Court nomination before the election. If a person works for a Catholic church or school, are they protected or religious freedom? Well, it depends on what function they work at the Catholic church or school. In other words, if you perform a ministerial function, which has some religious basis, let's say you teach religion or you help lead services and things like that, the court might view that as a ministerial function, and that you know, a church has that discretion and they're not subject to civil rights laws. What's become somewhat dangerous is this year the Supreme Court issued 2 decisions involving employees who were fired. There was one teacher who was fired because she had cancer, and another teacher who was fired, I think, because she was pregnant. And they argued that they were discriminated against based on sex and based on disability. And these were religiously affiliated schools. And they said, nope, we're exempt because they perform ministerial functions. And what the Supreme Court majority did in that case is they gave a great deal more discretion to the school to decide what's a ministerial function. I think there would be a good argument that, let's say, if somebody was the janitor at the school and was fired for being gay, that they would be able to say, look, that's not a ministerial function of the church or of the particular school. But what the court seems to be doing right now, the court majority is saying we're going to give a lot more discretion to faith-based organizations to determine who performs ministerial functions and who does not.